Well, good morning. My name is John Cusey, and I am with the American Enterprise Institute. I want to welcome all of you here today to this discussion on disability programs and how to make sure they serve those they were designed to help in the best way possible. Since Ron is such a good timekeeper, I'm going to get off the podium as fast as possible before he sticks me. But I do have to say, for those of you who weren't here for last week's session, which was amazing, that is posted on AEI's website. And I know everyone's in for a treat if this is even 80% as good as last Friday's. So without further ado, hand it over to Jason.
Thank you so much. I'm the Executive Director, Jason Turner, of the Secretary's Innovation Group, and we welcome you here. We're very pleased to have the opportunity to partner with the two most prestigious think tanks in Washington, Brookings and AEI. We think you'll enjoy this morning's presentation, and we want to work with you. The Secretary's Innovation Group is made up of 16 state secretaries, human service secretaries from around the country. We have 5 of them here today. Without naming them, we have New Mexico, Kansas. I knew I was good. Why am I? Come on, guys. Wisconsin. Michigan. And Florida. There. Okay, I did it. I'm sorry about that. And we're going to get right to work, and let me turn it over to Ron Haskins.
Thank you. I'm Ron Haskins from Brookings. I run a center there with Bella Sawhill called the Center on Children and Families. And as I mentioned last week, we actually have developed a little bit of an agenda on disability programs. About a year ago, we published a brief that went with our journal Future of Children on the SSI program, and we had a great agenda and a meeting at Brookings, and very lively. Some people even got mad, and you could see them yelling. They made some comment about my mother and so forth. So that was lively. And then we sponsored Jack Smulligan, whom I saw here a few minutes ago. There he is right there, who came to Brookings for about 6 months on, I don't think they call it a sabbatical at OMB, but whatever they call it at OMB, and studied SSDI and wrote a very nice paper with Jeff Liebman. And then we had a all-morning conference at Brookings, and as far as I could tell, anybody who could spell Social Security or SSDI was there. So it was very lively, interesting discussion. And now we're very pleased to be involved in this event as well. Jason has a habit of making an agenda completely jammed with all kinds of people, and this guy has 2 minutes, this person has 4, this person has 10. So you got to start on time, you got to get going. So we're going to make very brief introductions. First, we're going to have a summary of last week, which really was quite interesting, I thought. And Rich Burkhauser of Cornell is going to do that. He came all the way from Australia to participate in this conference. I've been here all week trying to catch up on his sleep. And also, Jennifer Christian is going to participate with him. She was a presenter at last week's event. She's the president of Webtility. And then that's going to be followed by Richard Pierce, who's a professor of law at George Washington University School of Law. And then Harold Krent will respond to Professor Pierce. He's the dean and professor of law at Kent College of Law in Chicago. We will then have a discussion, and then we will go back to presentations, brief presentations. Scott Semdera from the Congressional Research Service, I should say the incomparable Congressional Research Service. And then Joanne Barnhart, who's a former commissioner, not only, I think she's held approximately every position at HHS. So she was a former Social Security Commissioner, but she was also the head of HCF and had quite a remarkable run running programs for the federal government. Then we'll have another discussion, and then I'm going to briefly summarize, which means 15 seconds. Then we'll have a break, and then we'll go to the second panel. So Rich Burkhauser, however you've divided this up, come on up.
Thank you. So this is sort of like a two-part NCIS program, and last week was the first episode. I'm going to give you a recap in 6 minutes of what happened in the first episode so you can go into the second episode. I don't know whether I have slides or not that are going to come, but you've been handed out the slides that I'm going to talk about. So let me just, this is really called Just in Time. Okay, so what you see is that's me. Next slide is a book that I wrote, which Mary Daly and I wrote and read, and a few other people, maybe our relatives, read it. But one of the really exciting things is a reporter for the National Public Radio read it, called me up and said, I want to do a story on this, but I don't want to do all those dull stuff that you have in your book about with slides and diagrams and all that stuff. I want to tell this story in people and in the way their lives are affected by the program. So next slide. So we met a poor mother concerned that their child's success in school would end up with their losing welfare benefits. We saw a kid who seemed to be bright enough, but who was an SSI kid and was labeled as not making progress in school. We saw firms that specialized in placing TANF populations on the SSI and getting a bounty by the states of $2,000 for every kid they could put on the rolls. We saw unemployed workers who could work if jobs were there, but instead applied for and got on the onto the DI program. We saw lawyers who were willing to put them on to help them get on the rolls for free for the contingencies, and whose practices had grown enormously in the last 10 years doing that. And in the New York Times article a year ago, we saw insurance firms that after they had given up on placing their workers back into work, helped them to get onto the DI rolls. Next slide. This was criticized as being not representative of what's going on with the DI program and an explanation for its growth by the Office of the Actuary, and that was part of the discussion last Friday. And Steve Goss argued that the real reasons for the increase in the growth in the DI program were the aging baby boomers, like me. I'm the oldest baby boomer in the room, age 67 right now. A change in the retirement age from 65 to 66, and the entry of women into the labor force sufficient to gain SSDI coverage and prevalence catch-up. In fact, in a really exciting set of blogs that Mary Daly, my co-author, has been doing, she's been working with a guy from the CBO. Okay, now I'm too loud. A guy from the CBO. Next slide. And argues in her estimations, which I can't get into, that while Steve is right and that those three reasons do matter to some degree, 43% of the increase in DI is unexplained by his projections. Next slide. What she then showed, what she next showed is a growth, the actual growth rate of DI, the blue line, the projections of the actuaries, which also grow, and they're increasing. They're increasing whether you hold Goss's values constant, which would be the gold line, or whether you do the whole thing. The big point, and the point is here, that the actuary argues that that growth is not going to grow anymore in his 10-year projections. So who's right? Can we have trust in the actuary, and is this problem kind of going away? Next slide. Well, the problem is, that's what Steve said in 2005 when he underestimated the real growth. That's what he said in 2001 when he underestimated the 10-year growth. That's what he got wrong in 88 and 91 when he underestimated the growth. He did overshoot in 1996, and now he's telling us that, look, I knew all about this in 1996, and if you just projected my line up there, you would have been right, except that for the next 15 years, he forgot about what he said in 1990. So that's a neutral statement about what's going on in the argument between Goss and Mary Daly. Okay, so does this matter? I think it does. Next slide. If you believe Goss, in 10 years, we're going to have 9.5 million people on DI, and it's going to cost $157 billion. If you just take the average of growth over the last 20 years, it's going to be 11.3 million and 187 billion. That actually adds up to a little bit of a difference. That's a 20% difference in growth that aren't projected in the liabilities of the system. So if we're not going to stem this, we're going to have to raise taxes, and we're going to have to raise them even more than what Steve is projecting. Next slide. This is also true of the SSI Kids program, a program that basically is a welfare program, but a welfare program that you only get on if you're able to demonstrate that your kid can't make progress in school. And as long as he doesn't make, or he or she doesn't make progress in school, you continue to get welfare benefits. That program has grown enormously. Next slide. What you really want to do is, though, rather than simply look at the growth across children, which is this blue line down here. You want to do it relative to the eligible population. And what you get, depending on what you think is the eligible population, is that there's either now 4% or 8% of kids who are in poor households eligible for the program that are on there. That might not be so bad if there wasn't any growth in this, but actually that amount, if you believe it's 4% now on that 200% line, it was 1% in 1990. It's increased by 400%, 4 times as many kids on this program who are eligible as in 1990, and that's true no matter what line you choose. Okay, so the bottom line here is that there's a real problem. We do need fundamental reform to take care of this, and that's what this program is going to be all about. Thank you.
Hi, I'm Dr. Jennifer Christian. I'm here on behalf of 2 people. I'm going to begin as Kim Burton from the United Kingdom. In the United Kingdom, they had decided as a society that they couldn't handle the continuing cost of disability in their national programs. And so they were really searching for a political solution. And they felt that there was a strong political question on whether helping people be in work or stay in work or get back in work was actually good for them. So they commissioned 2 scientists, Kim Burton and Gordon Waddell, to produce a book. Oh, where am I? To produce, I'm not ergonomically, okay. They were feeling the same paradox we are, that they, despite green line here, prevalence rates of injury, illness, and disease, despite yellow line, decreasing risks of health in the workplace, despite red line, better and better medical treatment, that what they were seeing was blue line, increased disability. So actually sort of similar package to here. And they commissioned this book, which was a result of an evidence-based review of the literature on the connection between health and work, answering the question, is work actually good for your health and well-being? And I hope you can look at the slide deck on the website, because I'm not going to show it to you now. But the answer was, yes, unemployment is bad for you. Yes, reemployment is good for you. Yes, coming off Social Security benefits and re-entering work is good for you. And that a little bit less strong evidence, but strong personal opinion, professional expertise, social experience, that sick and disabled people, whenever possible, should remain in work or return to work as soon as possible. It, generally speaking, increases health and well-being. And that they started to realize that within their disability population, they had 2 distinct subpopulations. One is people who've had a lifetime disability of some sort, a congenital problem, and then people who have experienced some sort of loss, an ability to function which was followed by some sort of loss, and that among that group, most of them actually had started as common health problems from which most people recover. And for some reason, this group of people had ended up on disability despite common health problems. We don't really have that distinction yet in this country. I hope that you, as you start to think today, will think about it in those 2 ways. And that going on disability, if you started with a common health problem, is actually a very unfortunate outcome. Worklessness is a poor medical outcome. Okay, I'm finished being Kim Burton. Now I'll be Jennifer Christian. And in our society, we're at a similar place as they were in the UK. And part of the reason is because in our societies, we have a gap in our social fabric that neither the healthcare industry, medical offices, doctors, nor employers think of helping someone with an injury or an illness to stay at work or return to work as their responsibility. In our society, there's really no one who feels accountable for the success of the stay at work or return to work process at this point. And I want to distinguish again in your mind between the idea of anatomical or physiological disability versus work disability. The question in work disability is, are you working or not? If you're work disabled, you're not working. So we have a problem as we communicate with one another, because in some sectors of our society, the word disability implies this impairment, and in other parts of our society, for example, in the disability commercial insurance industry, disability means not working. So as I said, we want to distinguish between people with the classic disabilities. When people talk about it, you have an image in your mind of a person who is in a wheelchair or something, that's the classic disabilities, and we have an increasingly large number of people whose lives have turned into creeping catastrophes. And so if we're going to think about trying to make a difference, we have to start thinking about when people develop an injury or an illness or a change in their ability to function, they start asking questions. It's normal for people to say, wow, I wonder how long I'm going to be laid up or out of commission. How long do I have to take it easy? What can I still do? What is it safe for me to do? What should I be doing in order to get myself well? When will I be back to normal, if ever? What does this mean about me and about my future? And how should I handle this challenge, this huge life challenge? And it was kind of a shock the day that we realized that really there is no one in society who feels responsible for helping people think through this decision. This is not part of a standard medical visit. That medical visit is kind of a ritualized, protocol-driven thing that's centuries old. We don't answer these questions in medical visits. Where do people go for the answers, and why do we think necessarily they're making good decisions when left by themselves? And time is of the essence. There's quite a lot of data. This happens to be from an unpublished study of workers' compensation claimants, but if you look at many data sets, they show roughly the same pattern, which is that people, if they are away from work too long, they never go back. So in this particular slide, this is time away from work in weeks. This is the likelihood of ever going back to work. This was with a large American employer. And the thing that turned me into a disability managing doctor was noticing that if you go out by a year, the likelihood of those people ever going back to work had gone down to very close to zero. But as time has passed, what I've gotten interested in is this, because this is where the slope is moving the fastest. By 12 weeks, the chances of these people going back to work had become cut in half. The reason is they're making decisions. And once they make a decision and have a strategy, our time is up. So in the reality check is that the individual has the most power to determine the outcome because he or she decides how much effort to make to get well. It's very tough to push a wet noodle up a hill. And by tradition and under law in our country, people have a lot of discretion about whether or not to go to work if they say they have a medical problem. And a practical measure of someone's commitment is the amount of inconvenience or discomfort they're willing to put up for it. So our challenge is to strengthen their motivation and ability to cope with their situation and provide them with an environment that's supportive so they can make the right one. Thanks.
All right, thank you very much. Now we're going to have Richard Pierce, who's going to talk about the critique. He's going to give a critique of the disability determination process. Richard, thank you very much.
I do. Thanks, Ron. Let's see if, there it is. Oh, what do I do? This? Okay. So, starting point, I've been studying this decision-making process for about 30 years now. I see lots of evidence of problems in the decision-making process. And I start really where Richard led off with the percentage of the population that's been determined to be disabled, work disabled, has doubled over the last 20 years. Pinning down the precise causes and the proportion that each accounts for and the causal relationship is difficult. I put it up there as about half. I think Richard's and Mary's estimate of 43.8% is as good an estimate as you're going to get. And that is almost entirely attributable to the 48 to 67% rate at which the 1,400 administrative law judges at SSA reverse decisions to deny benefits that have been made by 2 independent teams of examiners and medical advisors on the state level. Just that rate of reversal alone is combined with the doubling in the proportion of the population that has been determined to be work disabled is powerful evidence to me, but it is supplemented by the evidence of the massive variation in the rates at which those ALJs make decisions to grant or deny benefits. It ranges from 8.6% to 99.7%, with over 100 of the ALJs reversing the two decisions of the teams of examiners and medical advisors in over 90% of the cases that come before them. The reversal rate varies by region from 37% to 88%. Now, what are the sources of the problem? There's actually a very large number, and I would start off with just the inherent difficulty of the task. We know from the data from SSA that the increase, the big increase in the percentage of the population that's been determined to be disabled over the last 20 years falls in a combination, one of three categories of disabilities. One is chronic pain attributable to musculoskeletal conditions, and then the others are anxiety and depression. And there's a big problem here because we know from the data provided by the National Institute of Medicine and the National Institute of Mental Health that slightly over half of the population suffers from one of these disabilities. So it cannot be that the job of the decision maker in this context is just the yes or no decision of whether you suffer from chronic pain, anxiety, or depression. That would produce a situation in which slightly over half the population would be determined to be work disabled. So the task for the decision maker is the much more difficult task of determining the degree of the chronic pain, the degree of the anxiety, the degree of the depression, determining whether this person suffers from chronic pain, depression, or anxiety so severe that it makes it impossible for them to engage in any substantial gainful activity. And that's a very difficult decision to make because we do not have any objectively verifiable or refutable diagnostic criteria that can be used for that purpose. It's almost entirely a function of self-reporting, and there are big problems in trying to determine just how much pain, how much anxiety, and how much depression someone suffers from. Is it so severe that they really cannot engage in any substantial gainful activity? Other sources. The ALJs have no relevant expertise and little relevant training. They are not doctors. They have no medical training whatsoever. They're people we train in law schools. We provide them with no tools whatsoever that would be helpful to them in making these kinds of decisions. They're certainly far less qualified than the teams of examiners, medical advisors, whose decisions they routinely review and reverse. So I start there. That's a problem. Second, ALJs cannot be subjected to any quality control mechanism or to any form of performance evaluation even. When SSA attempted this back in the 1980s, they got tremendously powerful pushback from both the ALJ union and from the federal district judges, and they finally gave up because they were just getting clobbered in court all the time. Bottom line is today, as a practical matter, they cannot be subjected to any quality control mechanism or even to a performance evaluation. You cannot sit down with an ALJ and say, you know, 98% seems a little high to me, Judge. No, that's unlawful. The courts will hammer you in a hurry if you do. Another source is asymmetry in the important sense that there are 5 levels at which an applicant can get a yes. And if an applicant gets a no at any of those levels, the applicant can appeal. As a practical matter, SSA can do nothing when an applicant gets a yes. So this is a bizarre decision-making process where at each of the 5 levels, it's a one-way ratchet. And if the applicant gets a single yes, that's it. If SSA gets a no, the applicant can appeal it again and again and again straight through a circuit court of appeals. Another one, asymmetry in another sense. This system was originally designed not to involve lawyers at all. It was designed where the administrative law judges were supposed to do all of the questioning, the development of the record. It has evolved gradually into a process in which over 80% of the applicants are represented by professional advocates, lawyers or other professional advocates. It's become a very lucrative business. They make Last year, as I recall, I made $1.4 billion representing disability advocates. So this is something I know a little bit about because I've been teaching law for 35 years, and one of the things we do well is we teach students how to make a buck practicing law. That's our main job. So how do you do that in this context? You are paid if, but only if your client is determined to be so disabled that your client cannot engage in any substantial gainful activity in the economy. So there's 3 simple steps that you take to start with. Step 1, shop for docs. Make sure that you know of the thousands of docs that exist in the area, which are the ones that are virtually certain to say in every case, this person is so disabled that they can't engage in any substantial gainful activity. Send your clients to those docs. That's step 1. Step 2, when you look at the evidence that you accumulate about this person's health state and the effects of this person's health state, don't submit all the evidence, for God's sake. Be selective about it. So, submit only the evidence that's favorable. So if you get 2 opinions from docs that say the person is not so severely disabled that they can't engage in any substantial gainful activity, you chuck them in the trash and you submit only the one from the carefully selected doc who said this person is so disabled. Okay? Third, hug your pain. That is the message that all plaintiffs' lawyers give their clients in all cases. Hug your pain. Make a pain diary. Make sure that you are in touch with your pain at all times, that you experience your pain, that you write down at 10:57 this morning, I experienced this kind of horrible pain. Okay? Now, any doctor, I think, will tell you that is a horrible, horrible way to deal with a problem of pain from a medical standpoint. But from a legal standpoint, it's brilliant because you're mainly dealing with self-reported clinical symptoms, and what the client is then able to do is to make a credible presentation first to a doc and then to an ALJ. I am in horrible pain. Okay? So hug your pain is a big part of what we teach our students to do. Other sources. District courts defy Congress routinely by reversing about half of the cases in which ALJs deny benefits. Okay? The standard of review here is what's called the substantial evidence standard, and in most contexts that produces and is designed to produce a highly deferential system in which 85% roughly of the agency decisions are upheld. In this context, we know that federal district judges reverse about half of them in defiance of Congress's command as to what standard to apply. If you combine that high reversal rate with the understandable pressure that, that Mike Askrew applied on ALJs to decide very large numbers of cases because the queue was so long to get a decision from an ALJ, and the lack of power to SSA to appeal grants of benefits, you get a bizarre incentive structure where it's like, as a professor, I'm told, you can either give an A or a B. If you give an A, you need to provide only a brief explanation and no one will ever criticize you. If you give a B, you have to provide a 20-page explanation, and half the time someone will criticize you harshly and say you're all wrong. Well, I can guarantee you in that situation, I and most of my colleagues would give almost all A's. That's the bizarre incentive structure that now affects the ALJs who make all of these decisions. Next one. Applicants and advocates can sandbag because the record never closes. This is unlike any other proceeding, either in court or in any agency in this city. This record never closes. Moreover, the advocate's pay depends in large part on the amount of past due benefits. So the advocate has a powerful incentive to sandbag. So what they do is sandbag, not surprisingly. Okay, you say, okay, if I'm going to get some powerful evidence to support a claim of disability by sending somebody to a hand-picked doc who's certain to give that kind of opinion, I'm going to do that late in the process. Because if I do it early in the process, I get less of a fee. This incentive system here is bizarre but easy to understand. Next, SSA applies what's called a treating physician rule that in very important ways tilts the balance in favor of applicants, in favor of a determination of disability. And it particularly tilts the playing field in the very common context in which there's a very good advocate, professional advocate who's working for the applicant. What you know under the treating physician rule is sometimes just one visit, and certainly no more than 3 visits, to your hand-picked doc will get you for certain a yes decision from an ALJ. The ALJ has very little choice. Once you've chosen the doc that you know is going to say that your client is so disabled that he or she cannot engage in any substantial gainful activity available in the U.S. economy, then you do that 1, 2, or 3 times maximum, you're under the treating physician rule, and it becomes virtually impossible for an SSA to deny you benefit. That is a terrible way of making decisions. The Supreme Court unanimously criticized it and urged SSA to reconsider that rule in 2003. SSA has done nothing so far about that. Potential fixes. Well, the one I would do is eliminate the ALJ stage of decision-making completely. Oh, darn, I keep forgetting. Oh, somebody's very kindly doing this for me. I'd eliminate the ALJ stage of decision-making completely for a couple of reasons. First of all, I think it actually introduces errors rather than reduces errors, because the ALJs are less capable by expertise, training, and education to make these decisions correctly than are the teams that have first denied them on 2 separate occasions before the decision ever gets to the ALJ. Second, it would reduce the length of the decision-making process, and as Dr. Christian showed, the length of the decision-making process has horrible effects on the applicants themselves. Then I would authorize SSA, and this might require statutory amendment, to evaluate the performance of ALJs and to subject them to quality control mechanisms. That's crucial. If you're going to retain them in any role, they have to be subject to performance evaluation. They have to be subject to quality control mechanisms. We cannot tolerate a situation where whether you get a yes or a no depends almost completely on the luck of the draw of which ALJ is assigned to your case. Then what I'd like to do is roll back some of the statutory amendments that have been made over the last 20 years and either eliminate, modify, or reduce the compensation that the disability advocates get. The Supreme Court in 1978 held in the analogous context of the Veterans Disability Benefit System that a $10 limit on the compensation that an advocate could receive was entirely permissible. I think $10 would be about right in this context. What you do is you leave it to the legal clinics that many law schools have, where they help clients put together a file, but they don't do all of this sending them to the right docs and selective submission of evidence and the like. Provide a clear date for the closing of the evidentiary record, like every other kind of legal proceeding that exists anywhere in our legal system. Rescind the treating physician rule. I filed a petition with SSA asking them to initiate a decision-making process to do that 18 months ago. I've never even gotten an acknowledgement of receipt of the petition, but we'll see if perhaps they'll get around to that someday. Another possibility is you could just amend the statute to roll back the expansions that took place as a result of the 1984 statutory amendments. You could eliminate pain, anxiety, and depression as potential disabling conditions. I'm not fond of that solution, frankly, because there are people who suffer from chronic pain, anxiety, or depression that's so severe that I think it is unrealistic to expect them to return to the workforce. So I'm not crazy about that solution. That's kind of a, if nothing else works, approach. And what I want to do now is do a little bit of segueing to a different way of looking at this problem. Let's see if we could turn to the last one. Yeah. What I want to do now is start by giving an ad for 2 things. First, for the Americans with Disabilities Act. Congress had, I think, a great idea decades ago. When Congress passed the ADA, the whole idea was it is good in many ways to maximize the number of people who have physical or mental disabilities who are able to participate in the workplace. That's what the ADA was all about. And a lot of people have put a lot of effort out to try and implement that act. But we have to count it statistically as a complete abysmal failure at this point. Since the ADA was enacted, the percentage of disabled people who participate in the workplace has gone down. The percentage who are determined to be so disabled that they can never participate in the workplace has gone up, with all of the horrible results that we heard about last Friday and just had summarized to us today. So I think our mission today should be to try to implement the spirit of the ADA by trying to do a variety of things to get more and more disabled people back into the workplace. Now, I'm pleased that the next panel is going to be looking at a whole bunch of things that are outside the context of the SSA disability decision-making process. They're going to be looking at things like how employers, public and private sector employers, can be urged, enlisted in this effort and urged to take actions that will be supportive of getting more and more disabled people back into the workplace. But part of this has to come from fixes to the Social Security disability decision-making process. And so I got a couple more here. One is we need to implement review of all rewards of benefits based on pain, anxiety, and depression made in the last decade. Now, this has been going on to some degree for decades. It's called CDR, Continuing Disability Review. It went on to a considerable extent in earlier periods of time, and by the way, it turned out to be a win from a cost standpoint. The SSA recovered more money than it spent on the program. It has gone way, way down in the last few years, and that's kind of understandable. Mike Askew was under tremendous pressure to reduce the queue, to get a decision from an ALJ, so he shifted a whole lot of resources from the CDR process to the process of granting benefits, basically. And that was understandable, but regrettable, because now what we've got is a CDR process that isn't used very often. And it's also, this second bullet point, I think is unrealistic. This isn't going to happen for a variety of reasons, eliminate judicial review of the decisions completely. But it serves as a good reminder that in this context as well, the courts are a big part of the problem. Back in the 1980s, when SSA was implementing a quite ambitious CDR process, the courts got very, very upset, and particularly the Ninth Circuit issued 2 opinions that make it very, very difficult for SSA to engage effectively in this very important process of getting people back to work once they have been placed on the disability rolls. Now, I don't think there's any chance of anybody implementing my second bullet point here, eliminating judicial review completely. I do think it is entirely realistic, though, for SSA to set up a pitched battle in the US Supreme Court. I've got actually 2 cases in mind, perfect fact cases in mind, that would put these issues before the Supreme Court. I have no doubt then that the US Supreme Court would do what the US Supreme Court is supposed to do. Okay? Take a look at the big picture, understand that from a big picture standpoint, this is a win-win. Getting more people off the disability rolls and back into the workplace is helpful to the economy, and it is helpful to the disabled community. And I think the Supreme Court would understand that, and I think the Supreme Court would then do what it is supposed to do, and I think it would do so unanimously, as it did in 2003 in the context of the treating physician rule, and get the rest of the lower courts back on the right page. Finally, if I had my druthers, and this would definitely require statutory amendment, I'd make all the grants of benefits temporary. That recognizes both that there are a lot of false positives, a lot of erroneous grants that we need to account for, and also recognize that our goal should always be to get people back into the workplace to the maximum extent possible, not only for society's benefit, but for their own benefit. And I'll close with just a personal illustration of the way this works. My wife suffers from severe pain 24/7, attributable to a condition called Ehlers-Danlos syndrome. So the way she responds to that, she's a counterterrorism expert, she responds to that by working approximately twice as hard as I do. And what she finds is that if she spends a lot of time working with her colleagues, as she has particularly in the last couple of days, trying to minimize the risk of occurrence of such things as bombings of marathons and attacks on politicians using ricin, that she does not experience her pain nearly as much as she would if she were sitting at home watching the television, hugging her pain, the way I urge my students to counsel their applicants for disability insurance in order to make a buck representing them. Thank you.
Well, maybe a little bit later you could clarify where you stand on these issues. I hope there'll be time to do that. And now Harold Krent, who is from the Kent School of Law. Harold, thank you so much for coming.
Thank AEI and thank Brookings for having this symposium to shed light on these incredibly important issues. I recently completed a study for the Administrative Conference of the United States on the decision-making aspects of Social Security disability, a lot of which Dick Pierce alluded to. Obviously, I did not look at some of the underlying standards. I also agree with the thrust of some of the other speakers here that we need to look at reorienting the process towards a rehabilitation model, which would really behoove us all. But I also wanted to say at the outset that I speak here, this is consistent with my report for ACUS. I don't speak for ACUS, obviously I speak for myself. I wanted to focus on the asymmetry that Dick Pierce talked about, the fact that we have a system where you can have 5 bites at the apple, where applicants can continually get no's and then appeal up and down the process. As a result, we have 800,000 hearings a year, which is just mind-boggling, and the average ALJ is now tasked with trying to decide about 600 cases a year. And you can imagine what kind of due process goes into deciding 600 cases a year. But where I differ a little bit from Dick is that I'm not casting all the blame on ALJs, or at least much of the blame on ALJs. Many of them, most of them are hardworking. They just simply can't function appropriately within this system. So I want to step back. I also disagree with some of the constitutional analyses that Dick has that would suggest that we can do away with the hearing whatsoever. I don't think we can, given the statutory framework. So I want to ask myself, and I did during the study, what can the agency do, mostly, even with outside of Congress, to just make the system more efficient? So I have a couple of different suggestions, many of which are consistent with that of Dick Pierce itself. First of all, the agency can, within its own framework, exercise greater supervisory control. They have the power to decide to appeal even cases that are decided in favor of the claimants. Right now, they look at about 3% of the cases on own motion review, and they do it on a basis of random sampling. I think that's crazy. Look at the cases that are decided, that are unappealed, based upon those you think are most likely to be wrong. They have the heuristics. They should use them. They should base it on whether the ALJ is an outlier, the 99% grant rate, or the 1% grant rate. They should use it based on issues they think that the ALJs are getting wrong. Use your authority that SSA has to decide which cases to appeal to rectify the asymmetry that Dick Pierce talked about. So even though there's no performance standards, that, as Dick mentioned, there is the potential within the agency to decide which cases to appeal, and that sends a very good signal to the ALJs what they should be doing, even aside from performance evaluations. What about peer review? ALJs may respect the fact that there's other ALJs that are telling them they're wrong. Right now, there's this sort of schism in the agency. The ALJs are looked as a marginalized commodity. Let the ALJs go through rotations on this appeals council. Let them decide that their own colleagues are wrong. Wouldn't that do a more beneficial dialogue within the agency? So I think a relatively easy, streamlined review. And maybe we want to increase own motion review from that 3% of unappealed decisions, maybe to 5%, maybe to 10% in order to enhance the dialogue. It comes with the cost, but I think there are ways to minimize other costs within the system. Closing the record is a great example. There's no reason for it, no justification whatsoever, and yet the agency has not been aggressive, perhaps because of political pressures, in trying to stymie this inefficiency in the system. Obviously, we need an exception if something happens at the hearing where there's a need for introduction of evidence that it's brought to light because of the hearing. But because of this failure to close the record, think of what happens. Delays cost money, as Dick Pierce suggested. But at the same time, we have a problem of more hearings. 5% of the Appeals Council equates to 7,000 extra hearings a year. 3% of the remands are another 500 or so hearings a year, all because of the failure to say, close the record. It happens in federal court, it happens in state courts, it should happen in other agencies, it can happen in SSA as well. No statute needed, just a regulatory change, simple, close the record. At the same time, there are, unlike other agencies, there are no procedural rules on these claimant representatives that Dick Pierce introduced to you. They don't have to file particular papers in a particular order by a particular day. Because there is no representation at these 800,000 hearings, it would be easier for the judges if the claimant's attorneys presented evidence in a certain way, and they had a duty of candor so that if they didn't introduce a pertinent piece of medical evidence, there would be repercussions. Simply by rulemaking, the agency can streamline these hearings, make it more expeditious, and allow for a facilitation of settlement in cases where settlement's appropriate. Settlement permits the need for a hearing, and again, would save the agency time and the claimant money. The claimant would get their money more quickly, which is certainly important. Again, ways easily within the agency's power. So is the elimination of the treating physician rule. It comes with a nice source. We all want to believe that we have a treating physician that knows us and knows us better than anybody else. But first of all medical studies in the continuous care have suggested that we are not seeing the same physicians as much as we used to. So this notion of a treating physician has been undermined over time. I read many decisions where there were 8 or 9 treating sources in one particular case. How do you assess who's a treating physician? How many times do you have to see them? With what kind of relationship? And why should there be controlling weight? That then sort of perverts or skews the review process by the district court. So the district court is not looking to whether there's substantial evidence to support the ALJ. They're looking at whether or not there was enough reasons to discount the controlling weight of the treating physician. The stats are pretty striking. 35% of the cases from the courts cite misapplication of the treating physician rule. 10% of the appeals council remands, right? That's, again, thousands of cases because of the difficulty in applying the treating physician rule. But it's normatively unattractive because simply our medical care system with HMOs and PPOs has shifted over time since the treating physician rule was enacted. We already have a treating relationship as one of the factors for why we care more about a particular particular medical opinion, and that should be there. We should care more in terms of continuity, but it shouldn't be given controlling weight force. Then we have the idea, and this is the one where we would need statutory change. The idea of permanent disability is not consistent with the record in many cases. We can make a guess that someone is in a car accident, someone has a bout of cancer, someone has a heart attack. They may be temporarily disabled. It doesn't make any sense to say they're disabled for their lifetime and to change the presumption of overcoming that to the agency. So it's simply consistent with medical testimony, perhaps ALJ forecasting, to have a category of individuals who are will presumptively get better. That's what medical science will suggest. Not for sure, but that's what they'll suggest. Indeed, the Inspector General has estimated that we have about hundreds of millions of dollars a year are lost to the trust fund simply because the CDR process is not catching up, whether because of the lack of congressional will for funding or because of the agency's reluctance to have more hearings and make the backlog of hearings even greater. So we can carve out a set of claimants and say, you're expected to get better, and therefore, I think, try to restore some kind of balance into the system. We would need to have Congress enter into this. I don't think a decision as to whether someone is temporarily versus permanently disabled should be subject to appeal, again, to streamline the system. And again, this would be just one simple statutory change, which I think would lend some balance to the system. In conclusion, I just want to say again, many perversions in the statutory scheme and in the regulatory approach to it. We have to be careful because every time you touch one of these sort of threads, you may end up with a greater backlog, or you may end up with perhaps more grants, as Dick suggested, even though I think the SSA's numbers are suggesting improvement in that respect. The grant rate has been going down, the remand rate has been going down, the correlation between decisions, between grant decisions and number of dispositions has been going down. So there's been some progress here, but I think the agency should take more steps, and maybe with this one additional congressional step, to increase the efficiency of the process. But finally, I think what's so important, and we'll hear later on today, we need to think about a rehabilitation model to get people back to work, and that's even far more important than these changes in the decision-making process itself. Thank you.
All right, now we have ample time for discussion. Anybody want to raise a question or make a comment? We have microphones going around, and please stand up and tell us your name and make a comment or ask a question. Right here.
Larry Hartman, American Conservative Union. I was just interested in terms of the presentation on this whole process and how it needs to be reformed. How much of this is written into law, and how much of this is the way this is developed from rules and regulations by the Social Security Administration?
That's actually a surprisingly difficult question to answer, because I mean, there are a couple things where I'm sure Hal and I would agree. It's written into the statute. If you want to change it, you got to change the statute. There are a whole bunch of others where it's just kind of murky, and a lot of it has come from the courts. And when I read the statute, I don't see any of it in the statute, most of what has come from the courts. But what the courts, I think, are doing is, I think the typical federal district judge has no idea about the big picture stuff that we're discussing. And all that judge sees is a record that suggests that somebody's in pain or anxious or depressed, and it's misplaced compassion that induces them to say, damn, I'm gonna be generous. I am a compassionate, generous person. I'm going to award benefits when this stingy bureaucracy hasn't. And they have created lots and lots of law that I don't see in the statute, but that people like Joanne Barnhart and more recently Mike Astrew have to live with, or they have to do what I am urging to do, make some tough decisions, work with the Solicitor General to get these issues before the Supreme Court so that the Supreme Court will do its job of telling the federal judges, stick with what the statute says, don't make up a whole bunch of things based on whim and caprice. That's the best I can do in answering what's a hard question.
And just to add briefly, the treating physician rule is a wonderful example of this. It was brought out not because of the agency, but because of courts, and the agency responded to the courts by creating this controlling weight formulation. However, the agency could change it. It might force a reaction from the courts, and then we'd have to go up through to the Supreme Court, but the agency has the power to make the change. So there's actually a wide range of powers that the agency could use in trying to streamline this decision-making process. The ALJ hearing process and the appointment of ALJs, that's statutory. But nonetheless, all these other kinds of procedures the agency can have a laboring war in.
The treating physician rule is a particularly good example of this because we have every reason to believe that all 9 justices think it's terrible and would uphold a decision by SSA to rescind it. That's pretty much what they said in 2003. So that's something that SSA could do tomorrow, should do tomorrow.
Next question, right here in front. I guess you're just going to yell, yeah.
Okay, I actually have several comments because I bring ideas from other sectors. And the first one is with regard to the treating physician rule. The state of California made an amazing, good move in its workers' compensation system to decide that an evidence-based guideline trumped the treating physician. right? That's huge, that the best available understanding of how a condition should be treated would trump the treating physician unless there was evidence presented that the guideline didn't apply. So I totally support the idea that you undo the treating physician, but you have to put something wise in place instead of the treating physician. Second one is I think we really need to shift the responsibility to the employer to prove they've made a reasonable effort at accommodation, because we in physician world, we know that an awful lot of the time the problem is the employer is not at the table. The employer has decided to just dispose of what I would call a used employee. And I used to work for EPA before I went to medical school, and reduce, reuse, recycle. We actually have an issue here of aging workers with low educational attainment, limited skills, and lack of suitable work. And if the employer really was at the table with an obligation to try and reuse employees, we would see a different situation. In workers' compensation, a mechanism has been invented called the Medicare Set-Aside Trust. Medicare decided they didn't want to be a sucker anymore and let workers' compensation insurers settle out claims and put in a fictional amount for future medical, which the claimant would actually then spend on a Winnebago. And so Medicare said, we will not let you settle this claim without setting aside an amount of money adequate to pay for future medical for this person.
Jennifer, can I ask you to hurry, because there are at least 3 people in
Okay,
that.
I'm saying a mechanism existed. Third one is there is an idea called the therapeutic use of the courts, which has arisen for drugs and addictions, and it's a way that people and the health providers and the judges figure out a way to use administrative procedures to force people into treatment as opposed to putting them to jail. And we have recommended WebAbility in a previous report to Social Security that a huge thing that's missing is an evaluation of preventability or remediability as part of the determination decision, which would be helpful both to the claimant in terms of understanding your situation is not hopeless, and also help trigger for Social Security whatever rehabilitation efforts would be in place. And that would be part of it, would be sensible to have a duty to mitigate on the part of the claimant, that they have an obligation to show they've tried to or are trying to improve their situation.
In the back? Yes.
Hi, I'm curious with the 2 law professors why they wouldn't think about having a less skewed adversary process. In other words, the assistant U.S. attorney doesn't get into the mix until you hit federal district court, and there's a skewed process. There's no lawyers on the other side, and that's not in your recommendations, and I'm just curious about why we wouldn't try to inject a true adversary process to defend the disability decisions by the team.
I can think of no worse change that could be made in the decision-making process. It's a horrible idea. I've heard it from many sources. The ALJ union has been pushing for this for a couple of decades now. It's a terrible, terrible idea. So what do you do when you turn something into an adversarial process? You don't have a 2-hour hearing. You have a 5-day hearing. So how many ALJs do you need then? Will 1,400 be enough? No. You'd need about 6,000, 7,000 of them. And then you have to hire staff attorneys, right? You're not going to, I mean, there's got to be a staff attorney sitting there. He's got to prepare to try the case. He's got to, just a horrible, horrible idea.
And if I can
Other than that, I'm open-minded.
Yes.
First of all, I enjoy
Tell us your name, please.
My name is Lynn Tatum, and I am retired from working for an employer. I know Dr. Christian, so she won't be surprised if I disagree with most of her question, if that was a question, or her little speech with regard to, let's let Social Security disability somehow force employers to take people back to work. I'm on the program later, and I'll speak to that. But by the way, Jennifer, I totally disagree with what you said.
Okay.
That's not a question either, Dr.
That's right. Right here in front. Yeah, go ahead.
Oh, sorry. So I've always been curious that Andrew Houghton, University of Hampshire, economist, and so not as well informed with the law. I've always been curious that people can introduce appeal a claim, an insurance claim, by introducing new evidence, and instead of forcing a reapplication. And I wondered if some of the people at Social Security who have access to a lot of the numbers, what degree the trend is for second application, third application versus appeal. Because if you're setting up a system where appeal is much more likely to yield an award, you'd see people stop a second application. How can you reintroduce new information at the ALJ level?
Yeah, the agency did make a change a number of years ago where you cannot make a second application for the same period. So what happens sometimes, so in terms of your issue, what happens is somebody will go through, they'll say maybe they lost, maybe they'll get better information about the next period, so they'll drop out of the process and then reapply with new information. But that's for a different period. So what happens more narrowly is you can continue to, you can't make a new application, but you can supplement the record with new information. So if you have another doctor or you never furnish the doctor's information, you can submit that even after the ALJ hearing, even when it goes to the appeals council level. So that's the issue. I think what the agency, that's for the same period. What the agency did stop was second applications for the same period. But you can be a repeat applicant, and indeed now the agency has changed its processes so it captures that information, because for a number of years it was a huge problem that the ALJs wouldn't know this was a third application from someone. So I think there has been some progress in that area that I don't know the actual statistics.
I mean, because you could set up a faster acting system where a second application or an amended application could occur, and use maybe the QDD system, which is highly specialized trained people, to cycle that through quicker. I know, of course, there's backlogs.
Yeah, there is no, you're right, there's no special track for someone who's on a second or third application. Just talking informally to SSA, they think they've made huge progress in making sure that there's not an abuse to the system.
Joe,
But
we
I
have
don't
a few
know.
minutes left for questions, so please keep them very brief, and panelists, let's keep the answers brief too. Joanne.
I just really wanted to elaborate on a point that Jennifer made, and because this whole treating physician rule came up last Friday and again today, and I'm certainly not here to defend the rule, but I do want to say this, that her point about you've got to make sure you replace it with something better. When I was at SSA, one of the analyses that I had done was to take a look at the incidence of certain categories of disability and how that compared to the specialties and the medical background and practices of the physicians who actually do the medical reviews, and I want to tell you it's exactly reversed. For the greatest number of the incidents and the category with the greatest incidents had the fewest doctors and so on and so forth. So a lot has to be done in terms of making sure that you have the right set of medical eyes looking at it if you're going to take on this treating physician. And I can tell you, at least when I was there, certainly the system through the DDS level and the federal DDS absolutely did not have the capability to do it.
In the back, all the way in the back.
Winford Cashel, America's Health Insurance Bureau. I'm recalling what Dr. Christian and others have said about the cost of delay to the individual who has an impairment, and I'm also thinking about what the speakers this morning said about the administrative process and what might make it more efficient. The agency has created a special track for individuals they think are going to get to yes quickly, a couple different categories. I wonder if they could create a special track for some subset of people they think they can get to a no quickly, and to give them a chance to redirect.
You know, it's an interesting idea, but I mean, to give you a sense of the delay, there's usually a year delay at the DDS level, and then more if you go to reconsideration, then another year at the ALJ level, and then another year at the Appeals Council, and then possibly a year or more at the district court level. It's amazing. So to change all the structure and make it more rapid and more efficient is a huge, daunting challenge. I don't think anybody has an idea, but you're right. I think some of the inklings that people have is if you can say, hey, you're a kind of person that might do better with rehabilitation. We might get a separate track for those people as a way to use that 12-week angle that we saw from Dr. Christian and try to make sure that there's some kind of decision up front for people who might benefit from this rehabilitation services.
I'd just add one other point related to, it ties in the delay with Dr. Christian's point about trying to get employers more involved in this. Because this decision-making process is so long, by the time somebody gets to the ALJ decision, they've had nothing to do with the workplace for years, because step one, before you tell them to hug their pain and go see the right doctor, step one is quit. For God's sake, have nothing to do with the job. You've got to sit there and credibly say at the hearing, I cannot work, I have not worked for years. And so usually any employer relationship was many, many years ago by the time we get to the ALJ decision.
One more quick question over right there. Go ahead.
Doug Holmes with UWC. One of the questions about the ALJ is, will they change their behavior? And I haven't seen any evidence that suggests that they will. For example, do they and may they take administrative notice? There's plenty of other determinations, although the standard may be different, of people that are disabled for other purposes or they're not disabled for other purposes. Do they take administrative notice of that as part of the hearing, and can they? And secondly, on this question of gainful employment and what's available in the economy, what's the quality of the record there? What is their duty? We expect that they would do a better job without being forced by someone else representing the trust fund to do something different that would be better.
Either of you want to comment on that?
Briefly, obviously, rulemaking might be of some help the more that the agency does help give guidelines. But vocational experts, that's the whole idea, that they're there to be neutral and to help to see whether there are gainful opportunities in the economy for work. It's supposed to streamline the process, but also give individualized attention to the claimant's impairments that go before the ALJ. Obviously, there's much work to be done in terms of those kinds of efficiencies, but I don't think you can have all these kinds of variables that arise in a very complicated set of issues with tens of thousands of pages of medical testimony. You can't always resolve to a few easily applicable rules either.
I do think generally what SSA needs to do is do a whole lot more rulemaking. And this question gets us into what's referred to as the grid rule. The Supreme Court upheld in 1983 that set out a whole grid of what jobs are available for people with various capabilities. So here's the problem. That was 1983. Hasn't been amended. So we know a lot about availability of jobs for elevator operators. You will not find any references to IT jobs because the whole sector of the economy didn't exist in 1983. That's another of the many contexts in which SSA needs to get into the rulemaking business on a real aggressive basis.
So, Richard and Harold, thank you very much. We really appreciate it. And now, all right, so two more brief presentations. Scott Sismondera from Congressional Research Service, and then Joanne Barnhart, former commissioner of SSA. Scott.
No. Thank you. I will be extremely brief, partially because the commissioner is following me, and anything I say, she's living. So she's certainly far more an expert at this than I am. But I have three comments that sort of a little bit about the context of what we've heard. The first is, and this is certainly something I'm sure Commissioner Barnhart can expound on further, is don't always assume it's easier to get a regulation through than a law. You talk to Social Security about that. You can talk to OSHA. You can talk to a lot of other administrative agencies. And so it's not always as simple as the agency having the right to, a regulation and that's it. Congress certainly will express its opinions about that and will get involved as much as they can in that process. That's number one. Number two is there is a structural issue here in that Social Security is not really permitted to spend money this year to save trust fund money down the road because they can only spend, in terms of their administrative budget, what the Appropriations Committee allows them to do on a year-to-year basis. And so whenever we talk about changes, if those are changes that are going to increase Social Security's short-term administrative costs, those are going to be very difficult to implement without an increase in the appropriations. Whether that increase will come in future years is always difficult to predict, but certainly in recent years, Social Security's administrative budget, affected by continuing resolutions, sequestration, has been limited. And then number three is, I've always been interested in the hiring process for these administrative law judges. It is, I think, a very, very interesting process, to say the least. The only process I think that might be more interesting is how you become a New York City firefighter. But it's almost similar in a way. If you want to become an administrative law judge with Social Security, the first thing you don't do is contact Social Security, because they are not involved in the process until later. You first wait and wait and wait until the Office of Personnel Management announces that it's going to give an ALJ exam. And then, once you find out about the exam, you better get your paperwork in quickly, because if you don't, by the time the exam closes, you're out. And the next exam might be 2, 3, 4, 5 years away, in which case you've probably moved on to another career. You then take an exam about administrative law, which, as Professor Pierce said, isn't really probably all that relevant to what you're going to be doing as an ALJ. Then you get put on a list, and then maybe Social Security contacts you. By the way, that's if their OPM is doing its job, and as Commissioner Barnhart experienced for many years, difficulty even being able to get to that list. So I'm not a lawyer. I'm not in the process of hiring lawyers, but I can't imagine this is the best way to get the best candidates for the job. The agency can't go out and recruit people. The agency can't recruit from the pool of, for example, disability examiners that have been doing this their whole careers. Instead, they wait and wait until OPM gives a test to mid-career administrative attorneys, and then they hire off that list. And if you're not on that list because you didn't get your paperwork in at that time, or at that time maybe it wasn't right for you to apply or whatever, you're out. And so the federal hiring process for all jobs has always been something that many people have said could be improved, but I think this is one area that if ALJs are going to be such an important part of this, and if SSA is going to employ the vast majority of ALJs in the country, which they do, then I think it's worth considering whether the agency should have a greater role in recruiting and hiring the ALJs. So those are my comments, and again, whatever I said, you just listen to it, but please pay attention to what Commissioner Barnhart said, because she's lived it, she's the expert. Thank you.
On my way here today, it occurred to me that we're gathered here to talk about Social Security, but it's really important to recognize the determined and valiant efforts of federal and Boston law enforcement to protect our homeland security. And I know our thoughts and prayers are with the families of those who were killed or injured in the horrific bombing in Boston on Monday, and in the wake of the action to apprehend the Czechoslovakian terrorists who perpetrated this atrocity. I was asked to respond to Dick's presentation. There's been so much in between that I'm sitting here frantically looking at what I intended to say and trying to decide if I can add things to it. But I was only given 7 minutes, Jason, so that doesn't even begin to... Thank you, Ron. You're always in my corner. That doesn't provide a lot of time to comment on all of Dick's presentation, let alone some of the really excellent observations and analysis that has followed. So I'm just going to focus on some points, some specifics of what Dick termed potential fixes for the process, and then share some thoughts. First, eliminating the ALJ stage of decision-making and making the second rejection at the DDS reconsideration the final decision. Dick is absolutely correct. There, as we all know, there is tremendous disparity among ALJ decisions, and that is from the standpoint of the percentages of allowances. And sometimes that can happen even in the same office. But the same issue exists among the DDSs, across the DDSs, and within individual DDSs. When I started working in the U.S. Senate in 1977, yes, I am a dinosaur. In fact, last week I told Ron I probably should have gone to the Smithsonian instead of coming here. The very first GAO report I ever read was about the disparity in SSDI disability allowance rates across 7 different states. 35 years later, the disparity's gone up and down. It's changed from the highs and the lows from state to state, but the fact remains, the disparity is still there. In my view, eliminating the ALJ decision stage will not only not eliminate decision disparity, but in fact will eliminate the opportunity for a claimant to have an independent review that's not biased by whatever it is that is driving those differences among DDSs. And that issue's been looked at and examined and studied for decades, and we still don't have the actual answer. Second, he recommends providing a clear date for closing the evidentiary record. Interestingly, that recommendation has substantial relevance only if the ALJ decision stage remains, because the time frame for a DDS decision and reconsideration is relatively short. One of the presenters talked about it taking a year. Actually, when I was at SSA, it was actually down to 82 days, and I believe now it's somewhere right around 100 or 110. I don't have the most recent data, but the DDS initial decision, then the reconsideration adds about 30, sometimes 60 days onto that. So it's, at least it has historically been well short of a year. But since the DDS reconsideration stage is relatively quick compared to the ALJ, the need for closing the record becomes less important, obviously. And as we all know, during the waiting time for a hearing, and that is extensive, beyond acceptable, conditions can deteriorate, health and medical conditions can deteriorate, and of course, in some cases, they can actually improve. I'm sure many of you are aware of the Disability Service Improvement Initiative that I undertook as commissioner. Key parts of those improvements were geared to address both the disparity and the timely submission of evidence. In my view, eliminating the second level, which is the DDS reconsideration or redetermination, which largely reaffirms the initial decision, and replacing it with a federal level of review that assures consistency, really provides the most promise for eliminating disparity. And I also believe that if claimants could be confident that what I like to call an independent set of eyes, federal eyes, was making the decision at that stage, fewer appeals would result. This actually was allowed to play out briefly in the Boston region, and it would be interesting to take a look at the data, which I don't think has ever been made public, to see exactly what happened in the brief time it was actually in place. Similarly, I think if DDSs knew that those same objective independent eyes were reviewing their decisions at the federal level, the quality of the initial decision would be strengthened. It could also provide for a better developed record to facilitate the ALJ decision making. Someone talked about the fact that ALJs have to do 600 cases a year, and obviously the development of the record is very important. As we look to the future of disability programs, I think it's important that any proposed changes, process, or policy we do it with an eye on some key points as a backdrop. First, the standard in disability in the United States is one of the toughest in the Western world, if not the toughest. We don't provide benefits for partial disability as our Western counterparts do, and we have a double eligibility standard comprised of the SGA earnings level and a long-lasting and permanent disability. Our programs are complicated and complex. They don't play out in black and white, but rather with substantial shades of gray. And as long as human beings are collecting, submitting, reviewing, and evaluating evidence, there are always going to be large gray areas. The multiple levels of review actually exist precisely to try and mitigate that fact. There are also clear outliers in decision results. The DDSs and the ALJs, and based on my experience, they really are outliers and should be viewed as that. The vast number of people who are working in these jobs are doing the very best they possibly can. I would point out that in some states, DDS examiners make $20,000 a year. The criteria for being a DDS examiner varies greatly across the country, and yet the financial risk liability for the decisions those individuals make can be tens and even hundreds of millions of dollars. Second, as long as the agency is engaging in what I call a downstream approach to handling claims, by that I mean simply trying to meet these increasing demands of enormous levels of appeals, levels of cases coming in. If they're not going to address what's happening upstream, the situation isn't going to improve.
Third, Social Security programs, be they disability programs or old age and survivor programs, are politically charged by their very nature. Therefore, proposals for reform and change, be it process or policy, should recognize that political reality and focus on what might actually be possible to accomplish. I have a few more comments, but I'm being stopped. 7 wasn't quite enough.
It's the first time I ever said anything to Joanne that she actually did. All right, so we have 10 minutes for questions and comments. Yes, right here in the back.
My name is Kevin McGuire. I'm the former president of the American Public Human Services Association. I was an administrator for public assistance programs in the state of Maryland for a long time. I'm now county commissioner in Westchester County, New York. One of the things that really hasn't been touched on is the fact that most states, because we're running a lot of programs with local taxpayer money, is that we're trying to maximize federal benefits, and it becomes an incentive to sort of like get people to apply for SSI and SSD. Matter of fact, it's probably to our best interest to try to do that. That's even worse when you have states that actually have commingled taxpayer money with federal money in the TANF program, because if you're putting your own skin in the game, you want to make sure you can maximize that out. It creates a sort of dysfunctional, distorted thing. That's why we wind up hiring these companies that, frankly, in my experience, don't even have as good a batting average as the average Joe who comes and applies for disability. We actually have awarded disability when you use at least that was my experience in Maryland. Less people get it than not. We just basically run these assistance programs, they get denied, they come back and reapply. The other thing I noticed is that for programs, which we had created one in Maryland for single adults, it's a cash assistance program, you have to be disabled. We found out that as the economy tanked, more people apply. Matter of fact, we found out that the people that were applying, before they applied, they were working. So it's actually working as some sort of an unemployment program for people. And it's, it's kind of wrong. My question, I guess, is for Commissioner Barnhart would be, would it make more sense to have some, as they do in Europe, to have a temporary or a partial disability program that will allow people to work? Because right now, if you can work a little bit, you get nothing. So it basically becomes this sort of disincentive to work.
Yeah, well, I mean, as I pointed out, I actually teach a class at Harvard at the Kennedy School on designing Social Security programs. And so I try to keep up with what's going on internationally, obviously, in Social Security. And as I pointed out in my brief comments, the U.S. does have a very tough standard for disability. I also, though, at the very end, talked about facing political reality. While I think that one could clearly make a case for creating partial disability, as our Western counterparts have done, we need to recognize several things. Their programs generally are much smaller, their populations are much smaller, their populations are much more homogeneous, that they're dealing with a lot less employers and everything else than we are in this country. It's, as I said, complicated and complex. It's an idea that I think sounds good. I just look at the political reality of that happening, and I wonder if we had partial disability, if the numbers and the concerns that are being expressed here today would just be exaggerated and aggravated with the concerns about the gray area of deciding whether someone has a partial disability or not. So I know I didn't really answer your question, but sometimes there just aren't good answers. I do want to make a comment, though, about what you said about trying to put people on welfare into SSI. That's absolutely happening. I do consulting to state governments across the country on welfare and moving people from welfare to work. And thanks to the good efforts of the gentleman to my left and the passage of the Welfare Reform Bill, Perora, in 1996, the fact is that up until the recent recession and high unemployment of recent years, the states had done a phenomenal job of moving people off the welfare rolls and into jobs. And what we were seeing, and I worked with 27 different states in a matter of a few years, was that the residual caseload that was left on welfare, oftentimes they actually were people who were likely to have disabilities. And that's one of the reasons that states were, in addition to financial pressures, but that's one of the reasons, because the people who were able to get jobs were basically getting jobs or moving on and finding, other means to support themselves.
Go ahead, quickly. Just one thing, Ron. I have tried to engage people who have disabilities, employable with employable with multiple limitations. In New York, they make it almost impossible for me to do it because they accept almost everybody, even though they're not disabled as far as Social Security would be concerned. But even with that, I have a large number of people that are never going to get anything under the Social Security rules or anything like that. New York has a general assistance program. Basically, if you come on to assistance, be it TANF or as a single adult, you can be on forever. And the problem is that as I try to engage people, I have large numbers of people that are employable with limitations or have low education, who have medical history, have mental illness, have criminal backgrounds, who want to work. They will work, but nobody seems to want to hire them. Right now, we're in the middle of a really bad sort of recession, and it hasn't really gone away for most people, at least on the bottom. Who are you going to hire? Who are you going to hire when you're out there?
Jason, I would actually say, given the fact you're talking about New York, Jason Turner's the person who ought to be responding to that, because when he was running the social services or welfare agency up there for Mayor Rudy Giuliani, he actually did an awful lot in that whole area of beginning who wanted to work and were able to work, got assistance in finding jobs, correct? So it can be done, is the point. None of these things are easy. They are complicated. They are complex. There are so many players. We've heard the various players, not even all of them, addressed today. I can tell you from having tried to take this issue on during my time at SSA, the number of so-called stakeholders, and I hate that word because it tends to dehumanize, but the number of people that are interested, be it Capitol Hill, the advocates, the claimants, the employers, the disability representatives, the medical people who make these decisions, they all have very different perspectives. And bringing those to the table to try to seek and craft change that makes sense and does not create some of the unintended incentives or disincentives that have been addressed here today, because I do believe people do what is in their best economic self-interest. I say that not as a criticism, but simply as a thinking, rational adult. The fact is they do, and it is not the fault of the people in the system and who are applying for benefits that they take advantage of failures that we have and that we allow to continue to exist in the policies and the process.
Questions? Yes, all standing up back there.
I have a question. The current system is geared to, as the gentleman over there from Westchester was referring to people who are handicapped in some way, uneducated or something like that. I have found that there is a severe deficiency in the system with respect to people who may be more educated, may appear to be fully functional, particularly people on the autism spectrum, where the system doesn't respond at all, where the administrative law judges say, you look perfectly fine, you're educated, you may be a college graduate, you can work. When in reality, the circumstances are that they can't really or may not necessarily be able to function in the normal competitive environment.
I think this goes back to the point that I made when I was sitting down here in response to the comments that Jennifer made, and that is we absolutely do not have the correct set of medical eyes looking at the medical evidence and that is presented in each of these cases. I say that having had an analysis done, as I mentioned earlier, which shows exactly the opposite, that for the greatest category of incidence of disability, we have the fewest doctors with that specialty, and it holds true right down the line. It's an alarming situation, one that needs to be addressed, but as long as that is the situation, you are sadly going to have situations where people whose specific and very narrow diagnosis is not going to be generally recognized and appreciated.
Well, the reason I ask that is because of the significant increases in terms of the population that is subject to this kind of disability. And it seems as though the system currently completely turns a blind eye to that and says, we can't deal with it.
Well, unfortunately, I don't think time permits me asking the questions I would need to explore to understand exactly what you're asking, so maybe we can talk afterwards, or you can talk to one of the other experts.
One more question, but it has to be quick. Yes, right on the...
Just a simple question and maybe a follow-up. What percentage of cases that are denied at the original DDS determination process wind up in adjudication before you have to...
Well, let me, I can't tell you what the number is today. I can tell you when I was there, and I don't think it's changed very dramatically. Roughly 40% of all allowances are actually, at the DDS level, 40% of cases are allowed. At reconsideration, somewhere around 11 to 14%, depending on the DDS, are allowed. Of those, the number I believe that go on to hearing is well over half. And of the ones that go on, and this is one of the reasons I would have been interested to have more time to talk about some of the data. The last data I saw was roughly 20% of the total end up being approved. The ALJ allowance rate, however, has been moving up steadily. It's kind of leveled off in recent years. It was about 60% 6 or 7 years ago, and now I think it's 62, 63, maybe even it's flattened out, they're telling me. So.
A quick follow-up is this, and then I'll leave it at this. I know that Maura brought up the adversarial issue, and that was the worst idea of the world. I totally agree with that. But isn't it true that then the ALJ process, because the administrative record of the original denial isn't even considered, isn't it true that the ALJ process is nothing more than a reopening of a new application?
I'm not sure I understand what you're talking about the administrative record. Not the record follows through from the beginning of the case. So. Yes, they do. Yes. That's why they were thousands of pages, and now we helped convert them to an electronic file. Yes, they did, actually. Yes.
All right, thank you very much. I'm going to make just one little comment in summary, and then we're going to have a break. And the comment is that if you'll notice on the schedule at 11:10, we're going to have 4 excellent proposals that are for consideration, and some of them deal with the same matters that we dealt with here. So let me just thank all the speakers in the first session. Very clear, coherent. It's just too bad nobody had an opinion. Thank you very much, and we're on break.